I found the eviction notice on a Tuesday. It was sitting on my kitchen counter like it belonged there. Cream-colored envelope. My name typed neatly across the front. No handwriting, no explanation, just legal formatting. For a moment, I genuinely thought it was a mistake. I've lived in this house for 32 years. I painted the walls myself, planted the maple tree out front when my son was 7, paid every property tax bill on time, even the year after my husband passed, when I had to take a second job just to stay afloat. Evicted? I opened the envelope slowly. Notice to vacate. 30 days. Signed by a property management firm I didn't recognize. My daughter-in-law's last name appeared under the ownership section. I read it twice, then 3 times. I didn't panic. That's the thing about age. Panic wastes energy. Curiosity is far more useful. I poured myself coffee, sat down, and looked around the kitchen. Nothing had changed. Same cabinets, same quiet, same mortgage statements filed in the drawer beneath the phone stand. Mortgage. That word matters. I walked to the filing cabinet and pulled the folder. There it was, my name, the bank, the outstanding balance, the automatic withdrawals I'd never missed. So how exactly had she managed to file an eviction notice on a house she didn't legally own? That's when my phone buzzed. Her name. I answered. "You got the notice?" she asked, voice crisp. "I did," I replied calmly. "You have 30 days, she continued. "We've decided it's time for you to downsize. The house makes more sense for us." "We've decided." Interesting phrasing. "On what authority?" I asked. Silence. Then, "The title was transferred after the wedding." No, it wasn't. But she believed it was, and that belief told me everything. She thought marrying my son had automatically moved assets into a shared future. She thought emotional pressure had become paperwork. She was wrong. "I'm not moving," I said evenly. "That's not really your choice anymore." Confidence is fascinating when it's built on misunderstanding. "I'll see you tonight," I replied. She hung up without saying goodbye. I stood there for a moment, feeling something settle inside me. Not anger, clarity. Because here's what she didn't know. 2 years ago, when my son asked me to help them refinance, I agreed. Partially. I co-signed nothing. I transferred nothing. I simply restructured, and I never removed my name from the mortgage. Ownership and mortgage are 2 very different instruments, and one of them still had my signature. If she wanted to play paperwork, she should have read it more carefully. That evening, when she walked into my house like it was already hers, she still believed she held the leverage. By the end of the week, she would understand exactly how wrong she was. She arrived that evening with a folder. Not a purse, a folder. That told me everything about the energy she was bringing into my kitchen. My son followed behind her, quieter than usual. He avoided eye contact, which meant he wasn't entirely comfortable, but he also wasn't entirely uninvolved. She placed the folder on the table like it was evidence in a courtroom. "We finalized everything after the wedding," she said. "You signed documents." "I signed refinance restructuring documents," I corrected calmly, "not ownership transfers." Her smile tightened. "It's all the same thing," she replied. "No, it isn't." And that was the moment I realized this wasn't malice. It was overconfidence paired with partial information. 2 years ago, When they were struggling financially, my son came to me asking for help consolidating debt. They wanted better interest rates, lower monthly payments, something that would set them up for the future. I agreed, but with conditions. I refinanced my home to access equity. I structured a private loan agreement to stabilize their finances, and I kept full lien authority attached to my name. I never transferred title. What she likely saw and misunderstood was a beneficiary adjustment tied to estate planning. Beneficiary does not mean owner, but to someone eager enough, it can look like destiny. "Show me the transfer deed," I said calmly. She hesitated for half a second, just long enough. "It's in process," she replied. In process. Translation: it doesn't exist. My son shifted uncomfortably. "Maybe we should just talk this through." She shot him a look, subtle but sharp. "We've already talked," she said. "The house makes financial sense for us. It's inefficient for your mother." I folded my hands on the table. "Efficient for whom?" I asked. Silence. This was never about square footage. It was about status. The house is in a good neighborhood, large lot, appreciating value. It photographs well. It signals stability. She wanted that signal. What she didn't understand is that signals without ownership collapse fast. "I'm not vacating," I repeated. She leaned back in her chair. "You can't afford to fight this," she said confidently. That's when I almost felt sorry for her, because she still believed I was reacting emotionally. She didn't know I'd already spoken to the bank that afternoon. And here's the twist she never anticipated. When we refinanced, I structured the agreement so that if any unauthorized claim against the property occurred, including wrongful eviction filings, the full loan balance tied to their stabilization funds would accelerate immediately. The bank had already flagged the eviction filing as irregular. They had questions, and when banks have questions, they don't whisper. They investigate. "You may want to double-check the terms of the refinance," I said gently. Her expression shifted, just slightly. "What terms?" "Exactly." My son looked between us. "What are you talking about?" I met his eyes. "The mortgage still carries my name as primary lien holder. Any forced occupancy change triggers review." His face paled. She hadn't told him everything. Or worse, she hadn't read everything. Confidence started leaking out of the room. "Wait," he said slowly. "You mean we don't actually own?" "You don't own it," I said calmly. "You're protected beneficiaries under a future estate plan. That's not the same thing." She stood abruptly. "This is manipulation." "No," I replied evenly. "This is literacy." My son ran his hands over his face. The foundation she thought she'd secured was never hers. And by filing that eviction notice, she had triggered scrutiny from institutions far less patient than I am. Within 72 hours, the first formal inquiry would arrive. And unlike family arguments, banks don't respond to emotion. It didn't take 72 hours. It took 48. My son called me first, not her. That told me everything. "Mom, did you talk to the bank?" His voice wasn't angry. It was tight. "Yes," I said calmly. I clarified ownership. There was a long silence on the other end. "They flagged the eviction filing," he said slowly. "They're saying it violates the stabilization agreement." "Correct." 2 years ago, when I used my home equity to help rescue their struggling business, I didn't just hand them money. I built a structure, a lien structure. If the property was subjected to unauthorized occupancy action, if external claim attempts were made, if legal instability was introduced, the loan attached to their bailout funds would be reviewed and potentially accelerated. They never read that part carefully because they never expected to turn against me. "We didn't know it worked like that," he said. "You didn't ask," I replied. "That's the difference." He exhaled sharply. "They're talking about reassessing our risk profile." Now we were getting somewhere. Banks don't like instability. Eviction filings, title disputes, conflicting claims, those things trigger audits. Audits trigger freezes. Freezes trigger stress. And stress reveals fault lines. That evening she called me, no greeting. "What exactly did you tell them?" "The truth," I said. "You're jeopardizing our finances." "No," I corrected gently. "You jeopardized them when you tried to remove me from property I legally control." Her breathing sharpened. "This is retaliation." "No," I replied again. "It's consequence." There's a difference. Retaliation is emotional. Consequence is contractual. The next morning, their business line of credit was temporarily suspended, pending review. That's when panic set in. Not rage, panic. Because leverage only works when you actually hold it. And the second the bank started asking for documentation, title copies, refinance clauses, occupancy agreements, she realized something horrifying. She had filed an eviction notice without confirming the legal structure. She had acted on assumption, and banks don't respect assumptions. My son showed up at my house that afternoon, alone. His shoulders were lower than usual. "She thought beneficiary status meant partial ownership," he admitted quietly. "And you?" I asked. I trusted her. There it was. Trust misplaced can be expensive. "They're reviewing our accounts," he continued. "If they accelerate the loan, we can't cover it immediately." Of course they couldn't. The stabilization funds I'd extended had been their cushion, their illusion of independence. "You should withdraw the eviction filing," I said evenly. He swallowed. "She already tried." That made me raise an eyebrow. "Already?" He nodded. "The property management firm wants confirmation from the title holder." Exactly. And the title holder was still me. For the first time since the wedding, since the slap, since the entitlement started blooming, I saw something shift in him. Not fear of me, fear of miscalculation. "She thought it would push you into signing over the house," he admitted. Push, pressure again. "You don't push someone who structured your debt," I said quietly. That landed. Because now it wasn't about the house anymore. It was about exposure, financial exposure, legal exposure, marital exposure. That night, I received an email from their lender requesting clarification of occupancy status. Professional, direct. I replied with documentation. Clean, accurate, unemotional. Within hours, the eviction filing was formally labeled invalid. But the damage wasn't erased. Audits don't disappear just because mistakes are corrected. They leave questions behind, and questions change how institutions see you. When she came to my door the next evening, her confidence was gone. Not replaced by humility, replaced by calculation. Because she understood now. She hadn't just tried to evict me. She had destabilized their entire financial foundation. And for the first time, she looked unsure. She didn't come in this time. She stayed on the porch. That alone told me she understood something had shifted. "I didn't mean for it to spiral," she said, voice measured, almost rehearsed. Spiral. Interesting word. "I meant to clarify boundaries," I replied calmly. Her jaw tightened slightly. "You knew we were trying to build stability," she said. "The house would have secured that." "No," I said evenly. "Ownership secures stability. Assumption doesn't." She exhaled through her nose, not angry, just recalculating. "My husband is stressed," she continued. "The audit has made lenders nervous. This could affect future financing." There it was, the real fear. Not the house, not the embarrassment. Creditworthiness. Because once a bank flags instability, it lingers. Lenders talk. Risk profiles follow you. "You filed the eviction," I reminded her gently. "You forced my hand." That made me pause. Forced. It's fascinating how accountability rewrites itself when consequences arrive. "No one forced you," I said. "You acted prematurely." Her composure cracked just slightly. "You made it seem like the house would eventually be ours. I made it clear the house would remain protected." Protected. That word matters. She thought protection meant inheritance. She didn't realize it meant insulation from exactly this kind of scenario. My son arrived shortly after. He looked different, less defensive, more observant. "We need to talk," he said quietly. Not to me, to her. And that's when I understood something critical. The power struggle wasn't between her and me anymore. It was inside their marriage. He turned to her. "Why didn't you show me the full refinance documents?" Her eyes flicked toward him, quick, sharp. "I did." "No," he said slowly. "You showed me the beneficiary section." Silence. And there it was. Partial transparency. She hadn't lied. She had curated. That's more dangerous, because curated information builds false confidence. "I assumed it was straightforward," she replied. Assumed. Assumption again. He shook his head. "You filed an eviction notice on a house you didn't legally control." That sentence carried weight, not anger, disbelief. For the first time, she wasn't arguing with me. She was defending herself to him. And here's the twist she still hadn't discovered. The refinance agreement didn't just include an acceleration clause, it included a protective covenant. If financial instability was introduced due to reckless asset claims, the protected property, my house, could not be used as collateral in any future joint financing attempt. Meaning, even if they stabilize their credit, even if the audit cleared, even if their marriage survived this, the house would never be leverage for their future. It was permanently insulated. She didn't know that yet, but she would. My son looked at me then, not as a parent, not as opposition, as someone who had quietly anticipated this exact scenario. "You planned for this," he said. "I planned for pressure," I corrected. He nodded slowly. And that's when something subtle but irreversible happened. He stopped defending her strategy. Not because he stopped loving her, but because he started questioning her judgment. Trust fractures don't explode. they widen quietly. That night they left without resolution. No shouting, no dramatic declarations, just distance. And in distance, clarity grows. Within a week, the audit concluded. Accounts reinstated, credit line reopened, but not without a note attached to their file, an internal flag. Temporary instability due to ownership dispute. Flags fade, but memory doesn't. She had tried to assert control through paperwork. Instead, she had documented her miscalculation. And once something is documented, it's very hard to erase. The audit cleared. The accounts were restored. On paper, everything returned to normal. But normal is a fragile thing once it's been exposed. My son came by alone a week later. He didn't stand this time. He sat at the kitchen table, the same one she'd placed that eviction notice on with quiet certainty. "I need to understand something," he said. "Ask," I replied. "Was there ever a version of this where the house became ours?" Not angry, not entitled, just honest. And that mattered. "Yes," I said. His eyebrows lifted slightly, but not the way she tried to secure it. I reached into the drawer beneath the phone stand and pulled out a thin folder. Not thick, not dramatic, precise. Inside was the full trust documentation, signed 2 years ago, amended 3 months before the wedding, and finalized quietly, without announcement. He scanned the pages slowly, then he stopped. "This doesn't transfer to me," he said. "No," I replied. "It transfers to future grandchildren." Yes, protected, deferred, isolated from spousal claim. Not because I distrusted him, but because I understood something he didn't yet. Love is emotional, marriage is legal, and legal structures outlast emotions. "If you build something solid," I continued gently, "your children benefit. If you don't, they're still protected." He leaned back in his chair. "You never intended to give it directly to us. I intended to protect it from instability." That word again, instability. It wasn't about punishing her. It wasn't about control. It was about insulation. She came over later that evening. He must have told her. Her posture had changed, less sharp, less performative. "You never lied," she said quietly. "No. You just never confirmed what I assumed." "Correct." She swallowed. "I thought marriage gave us leverage." "No," I said gently. "Marriage gives you partnership. Leverage comes from ownership." That landed differently this time, not as correction, as education. She looked around the house slowly, the crown molding, the old maple floors, the kitchen window. "It's a beautiful house," she admitted. "It's a stable one," I replied. "There's a difference." After a long pause, she asked the question that finally mattered. "Why didn't you just say all this earlier?" "Because some lessons don't stick when they're theoretical. They needed context," I said. She nodded once, not defeated, not resentful, just aware. The eviction filing was formally withdrawn. The property management firm issued a correction, and the paper trail closed. But the dynamic? That changed permanently. My son doesn't treat my silence as softness anymore, and she doesn't mistake planning for passivity. They don't talk about the house now, not because it disappeared, but because they understand it's not theirs to negotiate. She thought evicting me would secure control. What it actually did was document her misunderstanding. And sometimes the most powerful move isn't raising your voice. It's knowing exactly what you own and what you never gave away.